admitting people. So thank you for joining us today. We're going to be talking a little bit about planned giving basics. Presenting for us today are Cindy and Morgan Newman. Cindy is Senior Director of Investments at Oppenheimer and Company in New York. She's also a graduate of Cedar Crest and a former trustee. So she knows us very well. And she spent her career helping women make smart financial decisions and also paving the way for women in the financial services industry, which, historically had been a typically male-dominated area. And in that respect, she has partnered with her daughter, Morgan, who is with us today, to form the Newman Group. And Morgan is a director of investments with Oppenheimer as well. And she has her BA from Bucknell and certificate of financial planning from NYU. And so we are thrilled to have these two very knowledgeable and informative ladies with us to present today. So thank you so much, ladies.
Pleasure. Okay, so I'm going to kick off, and Morgan, you want to put up the slides?
Sure.
While Morgan's doing that, this is, I believe, the third of presentations we did this year with Cedar Crest alumni to create financially savvy women. And we're ending the year with this presentation, Estate Planning Basics. And I know Michelle's recorded the other one, so I don't want to repeat what we've already done. We have in particular done our stories and the earlier versions, but for those of you that are new, just the high level for me is that I am a graduate. I will reveal, because we are doing estate planning, the class of 78. I came to Cedar Crest unknowing anything about the school, where Allentown, Pennsylvania was. My best friend's mother was a guidance counselor, and she told Stephanie that she should go to Cedar Crest and take a look at it. And I said, okay, I'll go too. And that's how I landed there. I was very unsophisticated, the first of 5 to go to college, and landed in a spot independent from my home and a little bit overwhelmed. And Cedar Crest was incredibly welcoming. And I came to the campus with the anticipation of being an education major. I helped my siblings. I wanted to help other youngsters. And about a year in, I took an econ class with Wilma Mills, and she changed my life trajectory and ended up going down the pathway of economics and management studies while I was at Cedar Crest. Met my husband down the road at Lafayette. So it was a real home run for me, my experience at Cedar Crest. I landed in downtown on Wall Street as an assistant, because at the time in the 70s, they weren't hiring young women to be financial advisors. But I stuck through it through all the decades. I never left Wall Street. And through the years, I accumulated a wonderful client base of primarily women, but people from all walks of life. And about 10 years ago, decided that maybe I'd retire or something would happen to me, and what would happen with my lovely group of clients that I've established for decades. And I had asked Morgan to join me, the middle of my 3 daughters, to be the heir apparent to the practice. And I thought I would retire, but we've had so much fun working together and spreading our mission of empowering women financially through these workshops, that here I am virtually 10 years later, and we've evolved like the rest of the world and now doing it via Zoom. But hopefully one day we'll be back in person and not the too distant future. So with that said, let's move forward with regard to estate planning basics. This is about you guys, not about us. And it's about listening to your questions and giving you answers to what's concerning you with regard to what's happening in your lives from an estate planning basis. And I would say that I want to put the caveat, as I told Michelle earlier, estate planning really is the legal component of your financial life. And Morgan and I are not attorneys, and we are not accountants. Although we overlay this because it's a critical part of the financial planning process, and we have to have, as professionals, understanding of this. When you get into the weeds of creating a trust, and do you need them, you don't need them, whatever it might be, what assets to gift, not to gift, we are involved in that process, but we also rely very highly, significantly on your team and your team of tax advisors, your attorneys. And so we will be able to give you today a high level view of estate planning. If you give me too difficult a question, I'm going to very honestly tell you that we need to go back to the attorneys for these answers. But I think we're going to give you enough of a basis today that as you're sitting around, this is a good timely topic during the holidays, because money becomes part of the planning process with the family, to maybe raise some of these questions and issues or things to think about going into the holiday season for gifting, for charitable endeavors, things that might be able to give you a better basis to make these decisions. So with that, I'm going to turn it over to Morgan, who will get us kick-started through the first half of the program. I'll do the back half.
All right, thank you very much. And so 2 housekeeping items before we jump into it. I'm going to ask everyone to keep themselves on mute throughout the program, just so we don't pick up any background noise and it's not distracting. And then also, we like to use the chat room for you to send in questions, which we'll get to at the end of the program, or if it's appropriate at where we are, we'll include it then as well. If you don't feel comfortable putting something in the group chat, please feel free to send it directly to myself or to Michelle. Okay, so with that said, let's get started. So when we think about, before we think about estate planning, I first want to talk about what is an estate. And when I think about estate, my mind immediately jumps to something like Downton Abbey or Kensington Palace. And while yes, an estate is a large home, it also has a second definition of anything that you own, which could be financial, so it could be accounts, or it could be property. So if you have a checking account, you have an estate. So when we talk about estate planning, then it's the plan for how do we want to maneuver and distribute your estate if something happens to you, whether you get incapacitated, which we'll talk more about in a second, or when eventually you're no longer on this planet. And so estate planning covers the 2 areas of your financial affairs and then also any property. So that includes not just a home or multiple homes, but also any belongings that you have as well. So that's the purpose of the estate plan. We encourage everyone to have an estate plan because everybody has an estate. And as we go through this program today, to make it a little bit more exciting than just talking about legalese, we decided to include some celebrity mistakes that we've seen over the years to show you that even people that have a lot of resources and money and tons of people around them, that mistakes are still made even at the highest levels. And so when we talk about estate planning, we want everyone to have one. Someone who didn't have one was Prince. And when he passed, he had an estate of about $200 million, and there was no will or estate plan. And he had 6 siblings, and some that came out of the woodwork after he passed. And it took years for the estate to get distributed. I'm not sure how many years, but it was at least 2 years. And during that time, of that $200 million, the consultants and attorneys collected a lot of it, but the heirs and his siblings did not. So we want to encourage you, if you are Prince or if you are just, like Cindy and I, we want you to have an estate plan in place. Okay. So who needs an estate plan? Chances are you do. Like I said, everybody has an estate. So it's not just for the wealthy. It's just not for the princes of the world. And so without an estate plan, what happens is that now it goes to the courts. And so the courts are going to decide how and who gets all of the resources and money that you've collected over your lifetime, or if you're incapacitated, who's going to be making decisions on your behalf. And you can easily see how that may not be the person that you want it to be, or how maybe that it would get distributed in a way you would not want it to. And so it's your way to say, this is how I want my money and belongings distributed when I pass, and also as well, who is going to be making decisions for me from a medical perspective and a healthcare, a financial perspective if I become incapacitated. So we really want to highlight this in particular for certain people. I'm going to click through these real quick. I think that's all of them. So you especially need it if your spouse isn't comfortable with financial matters. So that usually is the person that the courts defer to execute an estate plan. And so if that's not their area of expertise, you want to plan to make sure you have somebody else lined up, ready to go. If you have minor children, obviously it's incredibly difficult if you have children to think about not being here, but you do want to make sure that, God forbid, something happens to you, they're taken care of, not just from a care perspective, but also from a financial perspective as well. If your net worth exceeds the federal transfer tax exclusion amount, which is almost $12 million for this year, Cindy's going to talk more about taxes in her section, so we'll hold off on that for right now. If you own property in more than one state, so you're dealing with the laws of multiple states, you definitely want to have an estate plan in place. And if financial privacy is a concern, and we're going to talk about more about that on the next slide. Okay, and you own a business. Sorry, I forgot that was there. Okay, so basic estate planning concepts that we're going to talk about today is planning for incapacity, healthcare, property management, planning for death, wills and probate, tax basics, lifetime gifting, life insurance, and trust. So this is a lot, and we could spend hours talking about just each of these in particular. So as Cindy said, it's going to be a very high-level conversation. If there's something you want to do a deeper dive on, please let us know, and we're happy to have that conversation with you. Okay, so planning for incapacity. So incapacity is any point in time where you are not able to make decisions for yourself. It could be something like you were in an accident and in a coma for a couple months. So someone obviously needs to make decisions on your behalf and take care of your affairs. Or it could be something like as you age, if you develop Alzheimer's or dementia, and with your slipping cognitive ability, you're no longer able to make decisions for yourself all of the time. And so that's what we look at as incapacity. So this can happen to anybody at any point in time. So we really want you to focus on having the incapacity plans in place. If you don't have a plan for incapacity, as I said, it's going to go to the court, and they will appoint a guardian on your behalf to make certain decisions. And then every time the guardian has to make a decision, they have to go back to the court to get approved to do it. So it's a timely process. It's a tedious process. So you just want to make sure that you can do this planning as much as you can, so that you don't want this area of your life to be in question and turmoil in an event you're incapacitated. And then your guardian's decisions, if you are not able to take care of yourself or speak for yourself, they might not be making decisions that you would want. So it's also a way for you to say what your wishes are from a healthcare standpoint. Okay, so there are documents, lots of legal documents, but specifically for incapacity, they fall into two categories: for healthcare and then for financial and property. So for the healthcare component, these are the three: the living will, the durable power of attorney for healthcare, or the healthcare proxy, and the DNR, which is the do not resuscitate. So they each do different things, and depending on the state that you live in, they may recognize some and not others. You may need one of them, you may need all three of them. So again, a time to go to the attorney and figure out specifically what is right for you.
Also, I want to add here, Morgan, I know these documents seem overwhelming, and thinking about, well, what do I need? Do I need this? When you sit down with an estate attorney, they're going to go through this entire checklist. And when you do it, you get this all done in a one-stop shop. And that's typically the way people do it. It's the way it should be done. They do a deep dive into your who you are from a financial and a family standpoint. And then they create all the relevant documents. It's the most, not only is it efficient, it's also the most cost-effective way to do it. So, I know you're looking at these individually, but they get done collectively in one fell swoop.
Correct. Thank you. Okay. So the living will puts your instructions in writings. And so it looks at what do you want and what don't you want in terms of treatment, in terms of medication. And it looks at very specific circumstances. And so you have to, when you do the living will and you work with an attorney on this, you're going to look at a lot of different possibilities of what could happen. And you'll have to make decisions on what you do and do not want to happen. Example, if you want to have life support or no life support, and under what circumstances you want it. The durable power of attorney lets you designate an agent to make decisions on your behalf. So if you don't want to think about all of those circumstances, you can delegate it out to somebody else to make those decisions on your behalf. Obviously, the risk here is that if you don't give them any instruction, that they might make decisions that you are not, that you would not want for yourself. And then the DNR is pretty, I mean, I think it's pretty self-descriptive, but it pretty much just says whether or not you want any life-saving measures taken if that ever happened to you. So like I said, different rules in different states depends on the documents that you need, which is why we encourage you to work with the attorney on it. Okay. Now for finance and property, there's different tools here as well. And so one of them, here's the three that we're going to talk about today: joint ownership, durable power of attorney. Like I just saw this, you're correct. You can have different power of attorneys for different things. So you can have a medical power of attorney, and you can have a power of attorney that takes care of your financial and your banking issues. I'll get back to that in a second. And then the living trust. So for joint ownership, so when you think about if something happened to you and you can't access your checking account or you can't pay your bills, you're like, well, how is that going to happen if you can't do it? And that's where having joint ownership comes in. If you said, you know what, as you get older, if you have a spouse that's joint on the account, they have the ability to do all of the same functions in the account that you do. For a personal example, my grandma and my dad are on a joint account so that my dad is able to take care of her financial affairs in a fast and timely manner. So obviously though, because when you put money into a joint account, it automatically becomes half, well, depending on how it's titled, but most times it automatically becomes half of the person that you're joint ownership with. So you want to make sure that whoever that joint owner is going to be, that they are a trustworthy person and they're not going to be draining it for their own personal reasons instead of using it for what it's intended for. Okay. Next is the durable power of attorney. Again, it lets you designate an agent to make decisions on your behalf. So if you are not able to make decisions when it maybe comes to your investments or to banking issues or how to manage your property, you're able to designate someone to do that for you. A special note here is that even if you have the documents drawn up by an attorney, most of the financial institutions have their own power of attorney paperwork, and they need it in order to recognize the power of attorney. So if you are a power of attorney or if you have a power of attorney, just make sure that that's also on file with the financial institutions that you work with.
And I want to say here that this is really in our wheelhouse because we deal with this a lot. And as being in the industry as long as I've had and seeing clients age and how you lose your cognitive ability over time, it's imperative that these documents are done in advance, so that, because once we get on that slippery slope with people, it has a significant amount of legal ramifications about now how to create this power of attorney when the person is losing their cognitive ability, and the firms are on the hook because we're taking direction from somebody that doesn't have all their cognitive ability. So my point is, I've seen this in real time, real life. I really am, if you don't have this document done, regardless of where you are in the life journey, I say you need to have this in your back shelf. God forbid something would happen that you would need to put, the institution or your family would need to pull this, because this is an incredibly important document to make sure your financial affairs continue on.
Yes. And then the living trust lets a successor trustee take over the management of the trust property. I'm going to let Cindy talk more about trusts and her section, so we're going to skip over that for right now. Okay. Wills and probate. So the will is the cornerstone of an estate plan. It is the roadmap and the directions that you provide your heirs and the courts about how you want your property and your assets distributed, to who and how much. You also get to name an executor, who is the person that actually goes through the process of doing all of the distribution of the assets. And this is actually an incredibly important person. We've seen people name executors that really should not have been the executor, and they're not. You want someone that is organized and responsive and going to act timely in this role. If you're working with an estate attorney and a financial advisor, they don't have to be an expert in wills and probate and all of this, but you just want someone that's going to be on the ball and responsible with getting this done, because this process, if you're not on top of it, can get dragged out a very long period of time. And the longer it goes on, the more expensive and just overwhelming and tiring it becomes. Also, in addition to the executor, the will is where you name a guardian for minor children. And like I said, you can have someone that is in charge of the care of your children, and then someone separate that's in charge of the finances. So it doesn't have to be the same person. So just think about who's in your life that would fill those roles appropriately. Can accomplish other estate planning goals like minimizing taxes. It has to be written and signed by you and witnessed. So a few notes that I want to make here as we go back. First is we don't ever encourage you to do the DIY or online versions of these documents. We had an estate attorney once say they actually love it when people do it themselves because they spend 3 times as much money trying to correct all of the mistakes that they made in the DIY document. So just be sure that if you're getting this done, that you aren't we discourage you from using the online softwares that's out there, even though I know that they exist and it's very tempting because it's much more cost effective and than working with an attorney. Another thing here is tell someone where your will sits. Going back to our estate planning mistakes made by celebrities, FloJo, she passed in 1998. She had a will, but nobody could find it. And so there was a multi-year long dispute after she passed between her mother and her widowed husband about whether the mother was allowed to continue to live in their condo rent-free or not. So I know that is not a living environment I would want to be in. So make sure that you tell somewhere where that will sits, and not just the will, but obviously all of your estate documents as well. And so when we look at the things that we own in our life, from our bank accounts to our home, there are certain things that pass through the will, and then there are things that can pass outside the will. So anything that has beneficiaries attached to it, so retirement accounts, insurance policies, annuities, it has a beneficiary, it passes outside the will. And then other things pass through the will. And so things that pass through the will go through the process of probate, which is the official way that the courts just formally recognize your estate, your executor, and start the process of distributing your assets.
I just want to stay here for 1 second, Morgan. Somebody, so there was a question I saw somebody asked about is what's the difference between a will and estate? I saw that question come up. Hopefully this answers the question. It's the cornerstone of the estate. It's that legal document that you create with the attorney, or online if you want, that just spills out all of your wishes and how you want your money to be distributed. And if there's trust going to get established, it is the cornerstone of the estate planning process. The other question I saw was with regard to the power of attorney. Does it go in perpetuity? And the answer to that question is it could, but you can change the power of attorney. You can change these documents, but every time you change a document, there's a cost attached to it. So I think when you're making these big decisions and making these legal documents, of course, life changes and we never know what's going to happen year over year, but you really want to do a deep dive on the profile of the family and who you believe would be the best people that you can entrust with your children, with your finances, and your family makeup and who at the end of the day you think is best suited for this. But things can be changed. So it's not right. Except for irrevocable trust, majority of what you create legally, you can go back and change. Also, by the way, our friends in Washington make it necessary on occasion to change things because the laws change, and therefore documents have to get updated, and our lives change, so they have to get updated. So I just wanted to add that to the right. conversation.
And one more thing on power of attorneys while we're talking about them, another thing that we see quite frequently is that, which gets misunderstood, is that if you have a power of attorney, that dies when you die. So your power of attorney cannot make decisions for you if you are no longer here. So they don't get to say after you pass, this is how the things are going to get done, because you are no longer here. So you want to make sure that even if that person is power of attorney now, what is the plan going to be for you are no longer here and that power of attorney ends?
That's right. Morgan raised a good point. When you pass, the power of attorney dissolves. It's no longer effective. Everything now goes to the will and the executor, who's now going to execute your wishes after your passing, not during your lifetime. And the executor role is done once the estate is distributed. That is a finite role, and once all the legal parts of your estate are done, the executor is now no longer an entity, and it's now distributed accordingly. So just looking at this from who the roles are and how they're affected.
Yeah. Okay. So back to probate. So we talk a lot about avoiding probate because probate is there's a few downsides to it. It tends to be a long process, even for small estates, of getting all of the I's dotted and T's crossed to get through the probate process. It tends to be expensive because you need to have attorneys involved most of the times to navigate this process. And it's also public. So if you're concerned about privacy, you don't want your, personal issues and situations exposed to the world. I don't know if people actually look this stuff up, but it's out there for the world to see. So there are ways to avoid probate. So some of them here. So it's how do you get things essentially to pass outside of the will? And so if you own property jointly with rights of survivorship, which is how most people have joint accounts, if you see the JTWROS on the end of the accounts, that means joint tenants with rights of survivorship. And you pass, that joint money automatically goes to the other owner of the account. Complete beneficiary designation forms for properties such as IRAs, retirement plans, and life insurance. Like I said, those things pass outside of the will, so you want to make sure your beneficiaries are up to date. We recommend checking on that at least annually, but every time you have a major life change, we would like to make sure that your beneficiaries are designated appropriately. And then use trusts, which I said Cindy is also going to talk more about. Another thing here.
Okay, I'm sorry, go ahead, Morgan, I cut you off.
Okay, another thing that I want to bring up here that's not on here is just general account titling. If you have an account that is just in your name, you can add what's called either a transfer on death to that account or a payable on death to that account. And what it does is essentially for things that would pass through probate, if like you had an individual brokerage account and you had a transfer on death in it, it's essentially the same thing as designating a beneficiary. It would pass around that. Use a personal example here. My great uncle passed away a couple months ago. I was transfer on death for one of his accounts, and thank goodness, because there are immediate expenses that come up afterwards in terms of funeral costs and whatnot. And so because I was able to, I obviously know that the documents and the systems, but I was able to have access to that account within a week where we still have not officially distributed his estate. So it's a much faster way to be able to start executing someone's final wishes and whatever that might look like.
Yeah, then I think that's exactly where I was going to go with what I was going to add. That the titling of accounts, which is exactly what we're talking about. You have there's more choice there than people realize, and it can be very cost effective and very time effective. The difference between jointly with rights of survivorship or tenants in common means you each own half. Rights of survivorship means you each own all of it. So you again, you want to be sure when you're titling your assets and putting accounts together that they're titled appropriately. But I also think on transfer on death, I think it's an unknown gem if it works for estate planning purposes, because you still own the asset. You're not giving up any of the control of the money, but at your passing, it immediately is transferred to that individual. So it does do a lot of solving. And for many of us, these are very simple ways to avoid probate and not have to really make this a lengthy process for a lot of what we own.
Right. And so like I said, we want to make sure you update this at life changes, because celebrity mistake number 3 is Heath Ledger. And when he passed, he had a will in place, which is great. It named his mom and his sisters, except that it wasn't updated. And 2 years before he passed, he had a daughter, and he wasn't married to the daughter's mother. So none of his assets went to his daughter. Fortunately, his family actually ended up transferring all of the estate assets to the daughter. But obviously, we know that not everyone always acts in the best interests of the estate. And so we want to make sure that as you go through life changes, that these documents also get updated with you.
Yes, I will say that from a personal basis and from a professional basis, money brings out the worst in people. It is amazing how people's persona changes when there's a dollar on the table. So whatever the point being with this is, the better, the more efficient and clearer your wishes are, and all these I's are dotted and T's are crossed, that there'll be less angst after you're no longer here, and that your wishes will be heard and hopefully affected.
Okay. With that, I will turn it over to Cindy.
Yes. Okay. I'm going to talk about lifetime gifts. So now Morgan was in the softer part of it, the presentation. I'm kind of more in the grind of it and talking about taxes. And I think for all intents and purposes, when it comes to taxes, the majority was based on where the federal state tax exemption is today. Most of this doesn't apply to us. Really, and there was an effort with the Build Back Better bill to change some of that, but it seems like, at least the recent news, is that not much is actually going to get changed with regard to a state tax. But okay, so with that said, federal gift tax, this is imposed on transfers that you make during your lifetime. So we all know it is gifting. We all have the maximum you can gift this year up to $15,000. I haven't looked at what it's going to be for 2022, but with the inflation rate, I'm sure it's increased in dollar amount. But so that means that you can give anybody, as many people as you want annually, up to $15,000 without having to file a gift tax return. It's not that you're going to owe any taxes on it. It's just that you're telling the federal government, I've used $16,000, I've used $1,000 more than my $15,000, which now is going to go against the federal estate tax exemption, which for this year is $11.7 million. So less, also notice all these say federal. This is just Uncle Sam. This is not the state. In the states, many of the states have their own rules. So we're just, for today's purposes, we're just talking about federal because that's what's all of us are impacted by. But check with your state, and I know New Jersey itself has a state inheritance tax, and so each state has its own rules. They want you to be cognizant of that. For those of you that have estate taxes at the state level and inheritance taxes. Okay. With federal taxes, the gift tax, as long as you give no more than $15,000, you can give it to as many people as you want, family, non-family, and you can gift away some of your money for the people in your life to enjoy it while you're here. The federal estate tax is meaning at your death, when you're no longer here, if you have an estate more than $11.7 million, then there's going to be estate taxes due on that. That's what the current level is, 11.7 million. Next year, due to inflation, it goes to 12 million. That's individually. If you're a couple, it's doubled. So next year will be $24 million between the two of you. At the second death, there's not going to be any federal estate tax due. If you fall into this area, you certainly want to have met with an estate tax attorney to have all of these documents done. You're certainly falling into trust. There's high-level estate tax planning when we're in these brackets that definitely there should be conversations had. The top rate for the federal estate tax is 40%, so it's high. So we really want to make sure, if you're fortunate enough to have that much wealth in your family, that you're doing the proper estate tax planning. The federal generation skipping transfer tax is if you try to keep it within a generation, or I should say, actually you pass it a generation further along, trying to kind of like keep the money in the system without paying federal estate tax on it. Uncle Sam says, no, you can't skip more than one generation. Otherwise, you're going to fall into the generation skipping transfer tax, which is also the same $11.7 million. Again, it's really for people of a higher net worth. Not that I hope that there are people on the call that have these issues, but I think with regard to the estate tax for the majority of us, federal level, it's a non-event. Although I do want to say this was done part of the Secure Act, I believe, this level, and it sunsets in 2026. So the federal estate tax in 2026 is going to go from 12 million or wherever it is at the time, and it's going to sunset back to 5 million. And 5 million in this environment with our homes and the rising values in stocks, Bitcoin, whatever you might own, people now start to fall into that category of where they have $5-6 million. Life insurance, we're going to talk about life insurance. All these things go into your estate tax. So maybe it might not be relevant today at 12 million, but if we cut that amount in half, maybe you start to think about in 2026, which is now only almost 4 years away. It's not that long a period of time, that maybe I need to start to think about doing some estate planning work, knowing that this is not going to stay like this forever. Although the caveat being is, with Washington, we don't know year over year what's going to happen. And with what's happening with the infrastructure bill, the social bill, it's got to get paid for. They're still wrangling this out. So there's nothing definitive there, although it does seem it's been more generous to each of us than we were originally thinking when they first sat down to hash this out. Okay. Next, Morgan. Lifetime gifting. We talked about being able to give people up to $15,000. Anybody you would like, any walk of life, does not have to be family, without having to file a gift tax return. And I think that the issue with this, and the reason I wanted to highlight this, I think it's significant that as an advisor, and I've stated doing this for over 40 years, watching clients age and watching how people get fixated on money, are afraid to spend, afraid to enjoy it, afraid to gift it out, and then die with wealth that they haven't enjoyed. So there is a fine line, not a fine line, but there's a line that we like to, as an advisor, I like to try to say, we don't want you to outlive your money, but in all likelihood, that's not going to occur. As we age as individuals, we become more of who we are. So if you're frugal and we don't clip coupons anymore because it's all done digitally, but when it was coupon clipping, if you did that back then, you're doing it more often today than you were then. And you're still very conscious about your pennies my point is that you don't just change your persona when you get to 65 or 66 and retire and say, I'm going to travel the world for the next 5 years and spend down all my financial assets. We really just become more of who we are. And my point is that you end up accumulating a fair amount of wealth that you leave when you're no longer with us. So the thing about lifetime gifting or gifting out, particularly as we're in this holiday season, it's also being able to see your loved ones enjoy the money. My aunt says the hearse doesn't follow, the Brinks truck doesn't follow the hearse. So just thinking about it, particularly as we're with our loved ones over the holidays, about who in the family could benefit, could enjoy it now versus waiting for you're no longer here. And with our longer life expectancies, this is becoming more and more of an issue. The one negative, and it does take the appreciation and the asset out of the estate. So there's some positives with regard to talking about trying to keep the estate below certain levels. Gifting it out takes it out and gives it to someone else to enjoy. If you're going to gift out capital, such as stock, which is more often not a way people do this, is that unlike when you pass, when you gift out stock, you're going to gift it out the price that you paid for it. So if you were a savvy investor 10 years ago and you bought Netflix at $10 a share, and now Netflix is over $300 a share, if you're going to gift out Netflix to your children, grandchildren, you're gifting it out at the basis of what you bought it at, so that $10. So they're getting, and if they decide to sell it, they're going to have a gain that they have to account for from a tax perspective. So that is one thing to think about if you're going to gift out property instead of cash. Just, you don't get a step up. You're going to give it to them at the price that you paid for that particular asset. Something to think about.
Mm-hmm.
Okay.
One thing to add here real quick, if you're approaching the $15,000 limit or looking for other ways to gift to avoid it, you can pay directly for someone else's tuition or medical bills, and that does not count towards the $15,000 limit for the year. So we see that a lot for grandparents in particular, gifting to grandchildren. Also
charity, philanthropic endeavors also don't count towards a $15,000 annual gift tax exclusion. So particularly when you're trying to do your charitable giving at year end. So we're not going to get into a deep conversation about trust. I saw someone ask about revocable, which I will address. But when your wealth starts to build and you have multiple properties and things get a little bit more complicated or intense, trusts become an effective planning tool, and they are done through the legal aspect of your lives. We see a lot of trust, and the most common is the revocable living trust. That's kind of like the starting one that is general, and most people we see with all different levels of wealth. And the revocable means it's revocable. You can create the trust, and you can decide the next day that you don't want it, and you can cancel it. You retain the owner, your control over the asset. and therefore a lot of people do it. And the primary reason people do it is that it can avoid probate, which is what Morgan was alluding to. It's essentially like somewhat like a will already created. So at your passing, you're going to have in there who's the beneficiaries and how those assets are going to get passed. So it's a really, that's frequently why people create a irrevocable living trust, from the perspective that it has a lot of flexibility, it avoids probate, and that it also protects you from creditors and gives you control over the property while you're still on this green earth. So I think I think significantly, those are the reasons why people do it. Where irrevocable is the other side of that conversation. Irrevocable is once you make the decision, the assets go in there, it's very difficult to undo it. And those typically are done because of there's larger dollar amounts. It's a way to set up shielding the income and creating an income draw for the beneficiaries of it. But it's another whole level of legal work that needs to go in there. And we would always say that you really want to think about it when you're creating irrevocable trust, that it makes sense. And then it goes into GRATs and GRUTs. There's a whole world of trust, depending on the level of complexity of your financial lives. But for a majority of us, the irrevocable trust is the general trust that generally will get created. That's going to be kind of like the one-stop shop that will get most of these things done. It is fairly inexpensive when you do it with an attorney, but anytime you start creating trust, and I'm not saying it negatively against attorneys because we need them, but that's how they're going to get compensated. So just make sure that it makes sense for you to create the trust, that your life is at that stage where some of these things are very important to you, and that a trust would be helpful.
Okay. Do you want to talk really quickly about the importance of funding the trust?
Yes, that's a good point, because we find that people create trust and they'll go to sit down with the attorney, and the attorney's going to say, all the assets that you own that that can be put into the trust need to be put into the trust. And if you don't fully fund the trust with all of your property that goes in there, then it kind of negates it, because you're still going to have to go through probate. So we've seen this circumstance. The attorney will give you a checklist, or they'll tell you what to put into it, and then the client leaves the attorney's office, and life happens. Maybe the bank account got in there, or the stock account got in there, but the house never got retitled. There's work that has to get done to get the trust, these assets into the trust. So it's just important that you note that if you're going to do this, that you want, in order to truly avoid probate, which is one of the key reasons for this, is that you've got to make sure that every asset that would be going through probate is properly put into the trust. Mm-hmm. So, when you're sitting with the attorney, they'll go through the checklist with you. Make sure that you come out with that checklist and you're diligent about doing that work, because that's going to need to get. That's where people will come to us and say, Cindy, can you take our joint investment account and put it into the trust? Yes. Could you send us the trust document? We retitle the account and we put it into a trust for you, just as the directions are. So it's actually, for most of it's fairly easy to do. Real estate's a little more cumbersome, but I just want to make sure that you check all the boxes and you get every asset that should be in there. Otherwise, it somewhat negates what you're trying to accomplish.
Yep. So celebrity mistake number 4 is Michael Jackson. And his mistake was that he created a irrevocable living trust, but he never funded it. Nothing ever went in it. And so his $500 million estate, the whole thing had to go through probate, and it took a really long time for it to get distributed. So let's learn that lesson.
Okay, life insurance. Life insurance has many different aspects in when it comes to estate planning. The one thing that it does do is it provides an immediate estate, so that upon your passing, if you have a $100,000 policy or $1 million policy, it immediately comes liquid and available for whatever need that you had set it up for. So it also could be used to you could leave Cedar Crest as a beneficiary of the estate of the life insurance. So upon your passing, while you're not gifting during your lifetime, the school could be a beneficiary of a part of the policy or all of the policy, as an example. So it's going to create an instant estate, unlike other assets and other accounts. So if you have real estate and it's part of the estate, and we have to take care of your needs like the burial or paying estate taxes. You need liquidity. We need money. And, maybe it's not selling the investment assets at that moment in time or whatever that needs to get done in order to take care of the immediate cost of the estate. Life insurance is one of those tools that immediately will provide liquidity. And the insurance companies are fairly very quick, unless there's some kind of issue with the death, they're very quick about paying the claim. So it does help solve a lot of issues immediately. It gives the family money to continue on if you go young and you have dependents. So there are many reasons why you want to think about life insurance and the estate planning concept. So people need to know, people think about life insurance, I think it's outside of the estate. It's actually it is part of your estate. So if you have $1 million life insurance policy, you own it, it's on your life, your wife or your children, your beneficiary, upon your passing, that's going to be that $1 million is part of your estate. So it's going to count towards that $11.7 million. The way that you can take it outside the estate is changing the ownership of the policy. And that's what's called an irrevocable life insurance trust, commonly known as an ILIT. And it actually, so now instead of you owning the policy, it's owned by a trust. And upon your passing, it goes into the trust and it pays depending how it's set up, it's going to give income and whatnot to the beneficiaries, depending on what the language of the trust is. But the point being is it stays inside that trust and it's outside of your estate. So a lot of people do life insurance planning and don't realize that, yes, you don't pay income tax on it when the claim gets paid, but it is considered part of your federal estate tax. And therefore, the way to avoid it being part of your estate plan, if you have a large estate, right now we're talking about the 11.7 million for this year or 12 for next, you might want to think about changing the ownership of that life insurance policy so that that passes outside the estate, if that's of importance to you. Again, when you're sitting down with the estate attorney, this stuff is absolutely coming up. This is like estate planning 101.
Okay. This is your 5-minute warning, Cindy.
Okay. Charitable giving. We can't get to this point of the year without talking about giving to your near and dear missions and causes in your life. I know we're asked all year long for money from the institutions that we gift to. I think I always like to tell people when we're helping clients plan for this, instead of doing a little bit here, a little bit there, think about what's the most important to you and do it more meaningfully, and therefore make that impact instead of spreading it. And it's okay to say to somebody, you know what, I appreciate it. We gave to you last year, but this year we decided that we're going to give to another organization because this year this is what's near and dear to us, and we can always add your other charities for other points of your life. But I have clients that spread like $10 around to 200 different charities. Like, why don't you think about really being what's really important to the family and making one truly meaningful gift? Charitable giving. There's several ways to do it. I'm going to talk about the donor advised fund on the next slide because I think that's more common that we see, but you can do it through outright gifts, charitable trusts, annuities. There's a whole host of, and large gifts can be done through private foundations. There's a whole host of planning that can go around for families that have large charitable intent and assets that they want to give out. And I think it's something that should be well thought out. And decide what tool is most appropriate when you decide you want to give charitably, because you can save gift and estate tax ramifications if it's done properly. And I want to hop to that slide for the donor advised fund because I think this is something, if you're unaware of it, this is kind of a great way to create your own charity fund. Essentially, that's what this is. And what you do is you decide you can give cash. But more often than not, we find, as the advisors, we would encourage clients, depending on what the profile looked like. But today, with the stock market doing as well as it has, and a lot of people having a lot of appreciation in their assets and their stock investments, that you can gift out shares. You could put shares of Apple into your donor advised fund, and you're going to get the deduction for the amount that you put in there. And you don't have to sell it. You put it in the fund, and the fund will sell it. And that's, so let's say you're going to put $15,000 in or $100,000 into the donor advised fund using Apple. You put the stock in there, the donor advised fund will sell it immediately. By and large, there are some exceptions to things you could do, but for the majority of it, it gets sold and then the money gets invested. So it gets in, depending on, there's a whole host of companies that do this, and the money gets invested into different funds and how you want to have the money continue to grow. And now your $100,000 is sitting in this donor advised fund. You've gotten a tax deduction. You have not paid any capital gains tax on that Apple stock. And now you have a little slush fund that you can give out to your charitable endeavors. And if your 100,000 over time goes to 108 to 110 because it's invested, you can gift out this amount of money to various organizations through the donor advised fund, as long as it's, you know, it's a certified charity that you could gift out. And it really does make it a fun way, and you can include the family's decisions and things that are important to the family. You can sit down once a year and talk about who you're going to gift to during the year. Money stays invested, can continue to grow, and that you'll over time be able to use this as a pot of money that you can distribute out to the organizations that are near and dear to you. Okay.
Two things to add on this slide real quick is that the donor advised fund is particularly great if you are someone that makes $100 contributions here or there throughout the year and then have to go back at the end of the year or in March to pull all of the documentation together for your CPA for tax season, because it's a one and done. It's just one donation or contribution versus a number of them throughout the year. And then also too, and the same way Cindy talked about giving highly appreciated stock to the donor advised fund, you can also do that directly to designated organizations. So somewhere like Cedar Crest, that if you had Apple stock that you were like, you know what, this would be great to sell it and give it to Cedar Crest, but I would have to pay a gain on it. You can give the stock directly and they can sell it, and then you won't have any of the gain. So we recommend this a lot actually for clients, especially now with what the market's doing, that have highly appreciated stock as a way to gift effectively and tax efficiently. Okay. So with that said, we've come to the wrap up of our program. And so as Cindy and I always say, we know we went over a lot of material today. We hope you took a lot of notes and got a lot out of it. If you have any follow-up questions for us, please feel free to reach out. And also, we always want you to walk away with at least one action item that you're going to follow up on, even if it's something like checking the beneficiaries of your retirement plan, or if it's something more in depth about sitting down with your estate attorney to go over these documents. So here's some questions to ask yourself about what we went over today. And as always, as a thank you for spending your lunch hour with us, we'd like to offer you all a complimentary 30-minute consultation with Cindy and I. It's a way to get any of your financial or estate planning questions answered and any concerns addressed. So I just dropped the link to the survey in there. It's super quick. If you just fill it out, I'll be able to contact you to set up a time to talk further. And so with that, I think I'm going to turn it back over to Michelle to see if we had any questions come through in the chat.
Yeah, thank you. That was, oh my gosh, so much information, but just fabulous. I want to put one additional plug out there while I've got you on the line. Cedar Crest does have plan giving options that we are more than willing to discuss with you. We have a website, which I'm going to drop in the chat in a second. If you just want to jump around there and take a look at things, or if you have specific targeted questions about ways to make estate gifts to Cedar Crest, I'm your contact. So please feel free to reach out to me with any questions or any concerns on that. So we're always grateful for those options as well. For the chat, we did have two questions that that got stepped over. Phyllis had asked, and I think she may have answered, you may have answered this, but just in case, main advantage of a revocable trust would be to avoid probate, or is there another advantage?
You know, I think avoiding probate is one of the big issues, because that's really, I think, what most people aim to do. And I think it also, it does help minimize cost and entitling assets. So I think there's some advantage from that perspective. I think the main advantage and the real stimulus for people to do it is because their estate can avoid probate. Remember then, if that's the case, if that's what your objective is, make sure everything gets in there. Excellent.
And then we did have a question about from Linda George, if there is a way to find out if someone had a life insurance policy or if they let it lapse, or if, and if they did keep, wait, I should just read it because it made sense when I read it. Is there a way to find out if someone had a life insurance policy or let it lapse if they passed and they did not keep anyone up to date on their financial details? Sorry, Linda, it took me 2 tries.
Well, that's a good one. I know each state has like an escheat, the area of the state. You can go to the state and search. I don't know. I would assume insurance companies report in there like assets that are hanging around that haven't been claimed. So that would be one of my first choices. You know, it's, I don't, you know, outside of that, I wouldn't really know without off the top of my head where to take that, because if you haven't kept accurate records, that person's paperwork doesn't have any information about potentially life insurance policies assets, then how do you know anything exists? Maybe if it was through an employer, you could go back to the company and ask if there was any benefits. But as a standalone individual, if you had no idea, unless you thought maybe there was a nationwide policy or somebody that they may have done business with, you could go back to that insurance company. Otherwise, I don't know of a resource outside of the state. Each of those states, our states have areas you can go for unclaimed assets.
All right, unless anyone has anything else, we are right on time, which is fabulous.
Awesome.
Thank you so much. This was crazy helpful information, a lot of information. So again, it was recorded. I'll send it out to everyone so that if you want to go back and kind of review and be like, okay, what did they say again? And I can't recommend enough, take these wonderful, intelligent women up on their offer to have a chat with them, just as a consultation, even if for nothing else, just to find out what your next steps need to be. Because I know for myself, at least, I'm always a little overwhelmed about even starting. But that is open to all of you, and that is, you know, was given to us by them. So we're so grateful for your time. It does look like Meg had a comment. I'm guessing this is directed back toward Linda's question. She said they found out about her father's by looking through the checkbook. Oh, genius.
Yeah, very good idea.
Cancel a check with the it had the policy number on it and everything.
Yeah, that's,
good tip, Meg.
Yeah, you have to be like a detective when you, and I think that's a great idea, because that everything was done through checks back then. So that is, if you're fortunate to find the ledger or the canceled checks, the bank account, that's a really good way to go back and do some research.
All right. Well, thank you so much, everyone. I hope it was helpful. I hope you enjoyed it. And a big thank you to the Newman Group for taking their time again today.
Happy Thanksgiving to everyone.
Yes.
Yes.
Thanks so much.
Okay.
All right, everyone. Have a great day.
Well, be safe.